All right, we're here for oral argument. Want to go ahead and advise you that although we're on Zoom, the oral arguments are being live streamed so that members of the public can observe it. I do want to introduce the other members of the panel. I'm Kerry Vander, and you have Judge Dan Traver, the newest member of our court, and also pleased that we have Judge Joseph Boatwright, a county judge in the Seventh Circuit, to assist us with our work today. You should have a clock in the screen here, so you each have 20 minutes. If appellant's counsel wants to advise me how much time they wish to reserve for rebuttal, I'll try to help in that regard. If you have a cell phone or other electronic device, make sure it's turned off so the arguments are not disrupted by that. And if appellant's counsel wishes to proceed, we will proceed in the case of Thompson versus Johnson 20-111.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Okay.
Although this is a case involving a contract interpretation, the overarching policy concern is whether or not the lower court was correct in departing from the bright line rule of determining whether or not when the parent-child relationship is severed, and instead redefining it or expanding it to be a subjective rule based upon the subjective view of one parent. The lower court correctly ruled that at the time of the decedent's death, ROB was the legal child of the decedent. This ruling was not appealed. However, the court went on to say that in regards to this policy that's before this court, ROB would not be considered the child of the decedent. In making this determination, the court construed the policy and interpreted the policy and made errors in two different ways. First, there was the introduction of parole evidence. And second, it was redefining the term children. In regard to the introduction of parole evidence, there was no argument by appellees in the lower court, nor was there a finding by the trial court that there was any language in the policy that the terms were ambiguous. And if you look at the policy that was included within the record and the sections that were cited by appellant in our briefs, it's clear that the language is clear and unambiguous. The policy prescribes the benefits that are going to be paid out if a decedent did not leave a beneficiary, did not name a beneficiary. The first is a spouse. It's clear and undisputed that he did not have a spouse at the time of his death. The second is a child. There is no finding, nor can there really be that there is a latent defect in regards to the term children. Despite this fact, the court entered two documents to ostensibly help it define the term children for this policy. It entered a joint stipulation and a consent that were drafted and executed months before the decedent passed away. This joint stipulation and consent were executed to were an agreement for a step-parent adoption to sever the rights of the decedent. Despite the fact that there was no ambiguity in the policy, the court used this joint stipulation and the consent to construe the policy to believe that the decedent did not believe that the ROB was his child at the time of his death. Not only does this violate public policy, but it creates an absurd result. It violates public policy in the sense that the courts have repeatedly ruled that any agreement to terminate the parent-child relationship without it relying upon a Chapter 39 or an adoption is void. So parents cannot just come together and agree to terminate the rights of their children. It has to be pursuant to those proceedings. So if the court determines that this joint stipulation upon the decedent's execution of the document terminated, or he believed that it terminated his rights, violates the public policy, and the joint stipulation there becomes void. And this undermines the entire purpose of that contract. This also creates an absurd result for the contract, because the court, as I said in the beginning, the court found that ROB was the legal child for the decedent. He made this explicitly clear in his ruling. So the court, in making this ruling, was stating that the child was the child for the decedent for all purposes except for this contract. That it doesn't make really very much sense at all, and really creates a huge policy concern for these insurance contracts, so that there's going to be and could be litigation in regards to now who is a child, and if parents and children then become alienated, say adult parent or adult children or parents become alienated, then we have to come into as the subjective beliefs of parties in regards to whether or not they believed that that was their parent or child at the time of their death. It creates
Counsel,
a huge
will you address for me something in your initial brief, maybe just elaborate it on a little bit, because it was not discussed nearly as much as it was below. If we are to accept Appleby's argument, what, if anything, does that do to how Florida Statute 63.172 is written? Stated differently, how does that particular statute, which seems to address how we view inheritance rights of children who are born out of wedlock, how is that statute affected if we accept Appleby's argument?
So it creates a huge problem, because I do a lot of probate litigation as well. So it creates a huge problem if you've got an intestate estate and you've got an agreement, then it could create a litigation and a severance of potentially a child's inheritance rights. And this is what we were arguing, a child's inheritance rights based upon nothing more than an agreement. And what we were stating over and over again is that there's a bright line rule that the state has over and over again reiterated, is that parent-child relationship is only severed in Chapter 39 or adoption. It is this bright line rule because parents have the duty to take care of children, and because of the inheritance rights, there's a right to be able to expect inheritance if there's no last will and testament. And so if there's not a bright line rule, then we go into subjective determination, and what a decedent was thinking at the time of his death now we get into will contests, which are inherently fraught with issues. So I think the courts have been really clear in that there has to be a bright line in regards to, because of the public policy concerns, because of inheritance rights, there has to be a bright line in regards to when we sever parent-child relationships.
Ms. Smith, the term child is not defined in the policy, correct? The insurance policy?
That is correct, yes.
So what prevented the trial court from using the joint stipulation to interpret the word child? Is there anything that the trial court did wrong in interpreting it the way they did by using the language in the joint stipulation, since it wasn't defined in the policy?
Well, Florida Power and Light, which we cited in our brief, requires that a court use plain and if there's a term in a contract, it is required to use use the term by its plain and unambiguous meaning. So the court was required to use the plain and unambiguous meaning of children. In the state of Florida, the plain and unambiguous meaning of children is the bright line test that Florida has used. Children are never a subjective standard. Children are always used as a very bright line test of when a child becomes a child, either through the statutes are very clear in regards to when the parental determination of the paternal line is made and when that can be done. And then we had a petition to determine paternity. And once the paternity is established, then it can only be excised or terminated through Chapter 39 or through adoption. So
under your bright line test, is the definition of child the legal child or the biological child or some other definition?
So it's both. So the state uses both. So you can adopt in a child. So that's part of the Bright Line test. So when a child, so the statutes allow for adoption, the statutes allow for a biological child. But once a child is identified as a child, either through biology, through paternity test, or through adoption, through agreeing to accept the parental responsibilities associated with a child, then there is the parental obligations associated with that child. So that's why the public policy concerns flow from those statutes. And that's why the courts have over and over again ruled that these agreements to sever parent-child relationships are void if they don't go through the courts, through Chapter 39 or through an adoption. And that's
Let me
why
ask you this, at the time of the decedent's death, it's clear that the minor child was the decedent's biological child. Is your position that at that time, the child was also the decedent's legal child?
Yes, and the court was very clear in making that ruling. During the final hearing in January, the court clearly said he is the legal child. He was the legal child of the decedent. So he made that ruling, but he said, not, irrespective of the fact that he was the legal child of the decedent, I am still finding that because of this parole evidence that I'm allowing in, that he was not to be considered a child for the purposes of this contract. The additional problem that we have is that the court relied on this joint stipulation incorrectly. There is a condition precedent that was written within the joint stipulation. The condition precedent within the joint stipulation specifically states that the determination of the decedent's parental rights would be based upon a payment of $100,000 and a final order of step-parent adoption. And there's several paragraphs within the joint stipulation that reflect that the decedent knew that his parental rights were not being terminated at the time of the execution of that document. He knew that he would have to sign a consent pursuant to the adoption. He knew that he'd have to make the payments of $100,000, and he knew that the second payment of $50,000 was expressly contingent upon the court rendering a final judgment, a final order on step-parent adoption. So even when the court relied upon the joint stipulation, it did so in reading only a certain sentence and did not read in toto all of the joint stipulation together. And the concern with that goes back to the concern over the overarching policy concerns, that if this was an agreement where the decedent's parental rights were terminated upon the execution of this document, the document is void. And you had two parties represented by counsel, as reflected in the document, two family law attorneys who understood the nature of terminating parental rights. And so the condition precedent is very important in regards to reviewing the document and the court understanding the document. Additionally, the court relied upon the consent in and of itself. The consent in an adoption does not terminate parental rights. Instead, a consent is basically a release, and then the final judgment of adoption is what terminates the parental rights. Additionally, this court in KAG determined that consents can be conditional. In this case, it would have been conditional because the consent was conditioned upon the condition precedent and conditioned upon the court agreeing that the step-parent adoption would go through. So the court erred in interpreting these documents incorrectly and determining that at the time of the execution of these documents, when he hadn't even paid the funds, the adoption hadn't even gone through, that he somehow believed the decedent, that ROB was no longer his child, even though legally ROB was still his legal child. Additionally, as the court is aware, this was decided on a motion for summary judgment. Because parole evidence was entered to help the court make its determination, if that was the determination and he was determining that the policy was ambiguous, then an order of summary administration was precluded. So it shouldn't even have been here because it needed to go to trial if the court believed it was ambiguous. So it was premature for there to even be an order on summary administration. Additionally, the court opined that both parties were entitled to the proceeds before the lawsuit. The court did not really elucidate why that would have been the case, but it said if you know, the insurance policy or the insurance company had said, actually, I'm going to reserve the rest of my time.
All right, thank you. All right, for the appellee. You're muted. Can anyone hear appellee's counsel?
Oh, he's still muted.
There I am.
Okay, thank
My
you.
apologies. Good morning, Your Honors. G. Charles
Good morning.
Willis, on behalf of the appellees, Marvin Johnson Sr., and Clara Johnson. This matter revolves around a joint stipulation and a consent, which the lower court considered as being the primary reason that he determined the purpose of the contract in the determination that the child was not a beneficiary of that insurance policy under the terms of the contract. The joint stipulation, as the court is aware, made several determinations. One that said decedent understands he is permanently and forever giving up his parental rights to an interest in the minor child. He agrees to sign all documents that are necessary to terminate his parental rights as to ROB. Part of that requirement was the condition that he pay $100,000. That $100,000 was deposited into Kenneth Wynn's trust account, the last payment being made on February 14, 2018, just shortly after the actual that was the final payment that was in effect resolved all of the conditions which he was required to perform, except for the entry of the signing of the consent for the adoption. This was done on February 21, 2018. So and in that consent, it says, I voluntarily, permanently relinquish all my parental rights to this minor child. So from the standpoint of the decedent at that time, he had complied with all of the requirements of that joint stipulation. Those funds were in an account, in an attorney's trust account. Therefore,
Let me ask you this. Do you disagree with the child court's ruling that your client, or their son, the decedent here, was the legal father of this minor child at the time of his death?
He was the biological father.
Are you taking the position that he was not the legal father?
Well, I think this is an issue that the decedent, when it says decedent understands he's permanently and forever giving up his rights to the child, that from the decedent's standpoint, he no longer considered him to be his child. In fact,
but that wasn't my question. The question is whether at the time of the decedent's death, whether this child was the legal child of the decedent.
Well, I think the court said he was his child.
Right. Now, I'm trying to find out if you agree or disagree with that.
No, not, well, I don't agree from the standpoint of how the decedent considered it to be his child.
Okay, but legally, was the child the legal child of the decedent at the time of the decedent's death?
Yes, I would think so.
Okay. So if that's the case, why should we go, what is the plain language of the contract? Why should we give it a subjective interpretation rather than an objective interpretation?
Because this was not an issue under Florida law. It was not a determination as to a family law issue. It was not an interpretation, as the court said, relative to Florida law. It was an interpretation of a contract. Trustmark had interpled this action for the purpose of having the court determine what that meant relative to a child. They weren't asking whether it was a legal child. They were asking, for purposes of the insurance contract, was he the child and entitled to the benefits? And the court clearly stated in the appellant's motion for summary judgment that based on the above findings, the court denies the request to find that ROB is entitled to the funds that are subject to the interpleader.
Based on that definition, so is your definition then for children in the contract would be the legal and or biological offspring of the insured, unless the insured doesn't think they are? In other words, I'm trying to understand if you were to write me a definition term, because my colleague points out correctly, it's not defined in the contract. But in order to uphold your theory of the case, how would you have to write the definition of children to give you victory in this particular case in the policy?
How would I write it in the policy?
Yeah, just define children for me. That corresponds with what your theory of the case
Well,
is.
I would say, since this is the insured's contract, and this contract was on the basis of the life of the decedent, that it would depend on whether or not he considered it to be his child at the time of his death.
What if there's a situation where instead of ROB being 7 or 8 at the time of death, he's 15 or 16, and the father is upset at him because he crashed the car. And he says, you know, I disown you. I don't want you to be my kid anymore. Do we have to have a separate proceeding every time that there's an issue over this to decide whether or not he meant it?
Well, I think this is a little different than the fact situation that you presented, because this.
Okay, what if he signs a written and witness statement that says my son crashed my car and I no longer want him to be my son? I disown him.
This is a joint stipulation that was approved by the court.
Okay.
So, I mean, this was an agreement between the parties who were the biological parents of the child, and agreed that he understood that he was terminating all of his parental rights.
What if mom is every bit as upset about the car as dad is?
Well, I think that's a different fact situation than what we have here, because there wouldn't be a court-approved order that said the parties have agreed that he no longer considers him to be his child.
So the magic of it is that the court's approval of the stipulation essentially legitimizes it, and that in any other situation where you would be disowning your kid without a court stipulation, then the typical definition of child would apply.
Well, plus there was consideration in this, and that the mother accepted the benefits of the joint stipulation approved by the court by accepting the $100,000.
Should we give credence to the idea that we should be able to pay via contract to terminate parental rights?
Well, I'm not sure that's the situation that we have here relative to what the Trustmark people have asked them to do, which is to find the child. The question is interpretation of a contract that's not based on Florida law. It's based on what the court determined to be between the joint stipulation and what his intent was in signing these documents and paying the money.
Sir, you mentioned Florida law. The court relied, I believe in its initial order on April 4th, 2019, relied on 2 cases in making its decision. One of them was the second DCA case, which states that the owner of a life insurance policy can fix rights by a settlement agreement. So I'm assuming that's what the trial court intended here, but the case goes on to say without specific reference in an agreement to the life insurance proceeds is only determined by looking at the insurance contract. So was there a specific reference in this joint stipulation to life insurance proceeds?
No, there was not a specific direction, and the court noted that in its ruling. The lower court noted that in its ruling. Because it stated this is a question of contract interpretation. There's nothing in the contract that says it has to, that the child is defined as a child under Florida law. So I've interpreted the contract and I've made an order.
Why reference those two cases then?
Why did the court?
Yeah, why reference those two cases about
Well, I think
the
the
settlement agreement can fix the rights in an insurance policy, but the cases specifically say it's got to be, you've got to mention the insurance proceeds in the joint stipulation or the agreement, which was not done here, correct?
That is correct. But the court indicated that although it didn't specifically state life insurance policy, that petitioner understands he is permanently and forever giving up his parental rights to an interest in the minor child, leaves no doubt that the insurer did not consider the minor child to be his child at the time of execution of those documents. That was a ruling by the court. So he considered the issue that it was not included in the joint stipulation relative to life insurance.
Well, that goes contrary to precedent that's in effect right now, correct?
Well, that's Florida precedent, and he said it's not an issue of Florida law.
Are we required to give that opinion any deference on appeal? Are we required to give that opinion any deference on appeal?
To give it any deference, yes, Your Honor, I think so.
I think you said in your brief it's a de novo standard on review, correct?
Correct.
So I don't think we have to give it any deference, do we, if it's a mistake of law?
Well, I don't think it was a mistake of law.
Well, be that as it may, I understand that that's your position, but
Yes.
I think that's a separate idea that, in other words, you're not suggesting that we're looking at this under a different standard other than a fresh, correct?
Correct.
I believe in your brief, you suggested that your client had done everything in his control as far as the stipulation to move it on to final judgment, and that the only thing left was for the mother to do what was her obligations. Is that what you stated in your brief?
Yes, Your Honor. And in fact, shortly after the joint stipulation was signed and the consent was signed, the appellant filed a petition for adoption on March 12 of 2018.
All right. But there's at least two other individuals who would have to act on in a certain way to get that stipulation to be a final judgment, wouldn't there? That is
Well-
that is her husband would have to go through with the adoption. I mean, if he died, it wouldn't happen. If he separated from the mother and no longer wanted to adopt the child, it wouldn't happen. And then the judge would have to approve it and find is in the child's best interest. So weren't there at least 4 entities that would have to take action to move that stipulation to a final judgment?
Well, but there was nothing else that the decedent could possibly do. He had performed every requirement under the terms of the joint stipulation. He
But say
had no control.
the stepfather had died before the decedent. Would that change the result in this case?
I don't think so. Because the court goes back to the issue of whether or not he considered it to be no longer his child from the standpoint of all of his rights relative to seeing the child, relative to child support, relative to any other matter relative to him being the father of the child.
Well, then how would that be different than Judge Traver's hypothetical that, father's mad at a 15-year-old son, signs a piece of paper, says he's not my son anymore.
Because we're still back to a joint stipulation executed by both the mother and the biological father of the child and approved by the court. And the mother
But one
accepted the
of the
benefits.
conditions for that to go through would have been over if the stepfather died. So that stipulation would no longer really amount to much.
Well, even if he had lived, he still had no control over the adoption proceedings. And in fact, the mother didn't even go for the adoption and was not divorced from the person or the parent who was going to adopt the child. And she waited 19 months to go ahead in order to do the adoption. even if the biological father of the decedent had lived, he would have had absolutely no control over when that adoption occurred. And so the second payment of the 50,000 was totally dependent upon whenever she decided to have the adoption. He had no control over that.
What if, imagine a situation where, for whatever reason, the step-parent adoption doesn't go through. It could be because, for any of the reasons that the Chief Judge Evander outlined, or any other reason at all. Maybe the trial judge just decides, I'm not going to approve it for some other reason. It doesn't go through, the trial judge denies it. The very next day, the decedent dies. Does your theory of the case change or not?
No, I don't think it does.
So your thought is that once somebody signs an irrevocable consent saying, I intend to no longer have anything to do with my kid, he's done. Basically, he has agreed via court-approved contract to terminate the rights of his child, and nothing can undo that other than fraud or duress.
Yes.
How do we reconcile that with the long line of Florida cases that simply say you can't do that?
Well, I'm not sure I understand that you can't do that.
So you're saying that you can agree to terminate a child by contract?
Well, you can terminate a child not just by adoption. Juvenile court terminates interests of parents all the time.
Right, but that's not by contract.
But that's by
So
court
in other
order,
words,
which is
my wife and I can't decide that we're upset at our child and sign up a deal and get some court to bless it and then have that child be terminated. Like, I think that's an unconventional statement of law. I'm not sure why you don't agree with that.
Well, I'm not disagreeing with that. What I'm saying is that we're in a different situation under an insurance contract.
Okay.
So if the insurance contract, if the decedent had 4 children and, and he's indicated to a lot of people that he likes 3 a lot more than the 4th one. And do we take that subjective intent into account in distribution of life insurance proceeds?
If you have the same situation where the parent had agreed pursuant to a joint stipulation approved by the court that relative to one particular child that he no longer had any parental rights or giving up all parental rights relative to the child.
So if he's, he and his wife had 4 children and then they divorce, and then he signs a paper with her that says, I like 3 a lot more than the 4th. I have no interest in the 4th, and then he dies. Your argument is that the insurance policy should be interpreted to divide the proceeds between 3 of the children and leave out the 4th. Is that right?
Yes.
Okay.
The other issue I'd raised in my brief was whether or not the appeal had been timely filed. There is a provision under the Florida appellate rules in 9.110K that states that if a partial final judgment totally disposes of an entire case as to any party, it must be appealed within 30 days of rendition. Although I had filed a motion to strike, the court allowed me without prejudice to bring this up in relative to my appeal. And I think this was a partial summary judgment in that the final judgment had not been entered until the later a court order, which is what was appealed in this case. But the court clearly stated in its earlier orders that were entered more than that time period prior to the appeal being filed, that the court denies the request to find that ROB is entitled to the funds that are subject to the interpleader. At that point, I think the court had made a determination that the ROB was not entitled to the funds and terminated any rights of ROB into the insurance contract, and that pursuant to the rule that was a partial final judgment that disposed as to ROB's interest.
Can I ask you the same question that I asked opposing counsel? Florida Statute 63-172, if we accept your argument on appeal, don't we substantively rewrite that statute?
No, I don't think so, Your Honor. This is just, the court was simply asked to interpret relative to that insurance contract, whether or not the definition of child applied in that insurance contract.
Well, doesn't
That's far
that
different.
doesn't that argument effectively import subjective intent into that statute as it relates to the inheritance rights of children who are born out of wedlock?
Well, I don't think it's subjective intent if the parties have agreed pursuant to a joint stipulation that he no longer has any rights to the child.
I mean, I think it's the definition of subjective intent. It has to do with the intent of the parties to that particular stipulation.
Well, but I think the intent of the parties was relatively clear. I don't think there was any question that he was giving up permanently and forever all of his parental rights. It's stated in the agreement. They both signed the agreement. They abided by the agreement, and she reaped the benefits of that agreement by accepting the $100,000. I don't think that rewrites the statute.
If no final judgment was entered, step parent died or step parent no longer wanted to adopt the child, or the child judge didn't approve it, would your client have had the right to seek time sharing arrangements with the child?
I don't think so relative to the joint stipulation.
Well, the conditions
was
under
approved by
that
the
stipulation wouldn't have occurred, right?
I'm not sure I understand.
Well, the conditions preceding, that is, that the final judgment be entered terminating his rights and allowing the adoption, would not have occurred. So if that was the situation, is it your position that he would not have been able to make a claim for time sharing?
Well, that was totally and solely controlled by the mother relative to when the adoption occurred.
All right.
And
All right, thank you, sir. Your time is, you can go ahead and finish answering, then your time is up. Do you have anything else you want to, as far as your answer?
No, Your Honor, other just than that he had executed a will the same day so the child was not a beneficiary of the decedent.
All right,
He left it
thank
all
you.
to his father.
All right, thank you. Any rebuttal? You're muted.
Thank you, Your Honor. Just briefly in regards to the issue in regards to an order denying a motion for summary judgment, Vanco Construction, Inc., cited in our brief, specifically says that an order denying a motion for summary judgment is not a final order that can be reviewed by this court. Appellees have not provided any law or rule or statute that would overrule or override that clear law. And so it's our position that this was a very timely appeal. In regards to the issues that were discussed between Appellee's counsel and this court, it is our position that until the final judgment of adoption was entered, that the appellee or the decedent would have had his parental rights, that he would have had the ability to timeshare. And additionally, this was a contract. If Taryn Beardall had not performed under the contract, the decedent would have had traditional remedies under the law, including motions to compel compliance with the contract, any other petitions or remedies. I mean, the argument that the decedent was just out on a limb and he had done everything that he was supposed to do and he was just simply relying upon Taryn to perform is not an appropriate argument because of the remedies that he had if she did not perform. As the court clearly identified, there was a condition precedent, and the joint stipulation did not sever parental rights. And it's clear that they didn't sever parental rights. And so the final judgment on the joint stipulation was not severing parental rights. There was never an agreement to sever parental rights outside of a Chapter 39 or an adoption. So unless the court has any additional questions for me, then I'll end at this point.
All right, thank you. Thank you both, and we'll be in recess.
Thank you very much, Your Honor.